Supplementary list. Item number 1, pronouncement of judgment.
So for what has been discussed about the interim order dated 54/2024 passed in WPC number 1 year does not call for any interventions. They are stand dismissed. No problem.
Watch.
Any mention?
The submission.
Item number 1. May it please your lordships?
Yeah.
Your lordship, the conducting counsel couldn't appear before this honorable court today because she is unwell. However, your lordships, on the previous date, we have seek time to file rejoinder affidavit. Your lordships, today we shall file a rejoinder affidavit during the course of the
I
day.
read the matter today. Who was arguing counsel, you said?
Dr. P. Agarwal, your lordship.
Lord, the issue which was raised, my
You have
lord.
given the copy to gender to you?
No, my
You
lord.
have served?
No.
Your lordship, we have not filed it. We have yet not filed the rejoinder yet, but we will file it during the course of the day.
1 week's time is 28th anyway.
Your lordship, may please fix the matter after 2 weeks.
What survives in the matter? Anyway, what's your name?
MS H. Das.
MS H. Das for the petitioner. Submits to the journal action will be filed in the course of the day. Well, this is matter for hearing after 3 weeks.
Highly obliged, your lordship. Item number 2.
Last occasion, no one appeared today. I
Now,
think is there.
yes, you're appearing for
Yes, my
the
lord.
respondent? Yes.
I'm appearing for the respondent.
It may be fixed for hearing.
Was
my
it
lord.
for today?
It may be fixed for hearing. my lord.
You don't need to file affidavit? No.
I have not yet filed affidavit, but
You already filed
if
affidavit.
my lord if my lord will permit, I will file the affidavit today.
Today?
And, yes, my lord. And next step may be fixed for final hearing.
When do you want the matter fixed for hearing?
Anytime depending on the convenience of this honorable court, my lord.
Is your name?
And Z. Lutha.
Mr. Z.
It is on record.
Direct counsel for the respondent. Prays that he submits that the affidavit will be filed in the course of the day. You won't want to file a rejoinder, I suppose.
No.
Yes. Accordingly, it's a matter for hearing after 2 weeks. Yes. You take a date. Yes.
Item number 3.
Have you filed after the service?
Yes, my
It's
lord.
been filed.
Yes, my lord.
They've been served.
Your lordship, on this date, it was fixed for filing of affidavit from their side, your lordship.
You
The
are
respondent-
MSC Surana.
Yes, my lord.
But last time you said that they've been served and you wanted to file an affidavit indicating service. Have you filed affidavit? No.
No, my lord, no.
Yes, Dr. Mozika.
But I'm praying for some time.
Why?
I've received instructions, my lord. I'll just prepare the affidavit.
Yes. Another thing, number 3 is returned unserved.
May I please, my lordships, I shall take steps again to furnish the copy.
Yes, Dr. Mozika Leonard, ESGI, with so for the respondent number 1 and 2. Praise for further how much time?
10 days time.
2 weeks time
2
to
weeks time.
file affidavit.
My lordships, meanwhile, I shall take steps.
MSC Rana Also, players will be allowed to take fresh steps on the performance for number 3 within 3 days. Yes. 4 and 5 remains. You have to file service affidavit for them. Except that they've been served. For the remaining affidavits, petition to obtain status of service. List after 2 weeks.
Item number 4.
They're connected with 3 and 4.
Connected. This together with LPC 1 to 8 of 2024. Is service incomplete in the other matter also? Similarly.
Similarly.
Same respondent.
Send this.
Yes, my lordship.
Sorry, yes.
Supplementary list, pronouncement of judgment, item number 1.
In the considered view of this court, the question of limitation in a fact circumstance of instant case deserves to be examined firstly in light of Order 14, Rule 2.2, as to whether a primary issue can be framed which can dispose of the suit on an issue of law only, and secondly, whether the benefit of Section 14 of the Limitation Act will be available to the respondent in instant case, keeping in mind the entire issue of limitation herein is a mixture of law and facts. In these circumstances thereof, the matter of framing of the issue in a question of limitation deserves to be examined by the trial court. According matters to stand remanded back to the court, Assistant Deputy Commissioner, Circuit Court, Pulbari with Gaurav Hill for re-hearing, and the same shall be completed as expeditiously as possible. Impugn order dated so set aside, please.
Item number 2.
The matter being situated thus also includes the fact that prescription of age is as per Section 23 and 29 of the Regular Police Act, coupled with the added fact that the recruitment process is already underway. The last date received applications being as far back as 31/5, nothing survives consideration in instant petition. Seems calling close in this board.
Any mention?
May I please, Your Lordship, I beg to mention item number 24 and 25. Your Lordship, in this matter, we needed some more time to find the relevant judgment.
And the relevant judgments?
Yes, Your Lordship.
What's the
Therefore, we
matter
needed, if Your Lordship may grant us 1 week time.
Service matter?
Yes, Your Lordship.
What's the other side?
I have informed them.
Where's Mr. Sen?
I have informed them, Your Lordship.
Okay, after 2 weeks, right?
Obliged, Your Lordship.
May we please, Your Lordship? Your Lordship, I beg to make a mention for item number 23, Your Lordship. Your Lordship, on personal grounds of the conducting counsel because of his on bereavement, Your Lordship. Your
30?
Lordship, I pray 23, Your Lordship. I pray for
23?
yes, Your Lordship. On personal grounds of the
Who's the counsel?
S-Dep, Your Lordship, from Kolkata. I'm on behalf of respondent number 6, Your Lordship, State of West Bengal.
My Lord, respondent 6 is the government of West Bengal. They are supporting the case of the petitioner. They have a very small affidavit. My Lord, at least since I am for the petitioner, I can begin my case and I will very well place their affidavit, and if they want to really add something more to it, the matter may be taken up another day. But at least, some day case has to begin. Because for one reason or the other, though bereavement may not be in someone's control, but when
That is the
bereavement...
main consideration that's hanging out. This court said that it's a question of bereavement. So can we be so brutal?
My Lord, true. That's why, my Lord, that's why, my Lord,
men's are hearing, when a mention has been made on account of bereavement. I can understand on question.
True, my Lord, but by our experience, we have also learned when the bereavement comes without any specifics, then sometimes, my Lord, the very nature of bereavement comes under cloud. Be that as it may, my Lord, the words coming from the council have to be taken with great respect. So, if only, my Lord, because they won't be prejudiced in any manner, since they support us.
Tiwari, since
Well, I understand.
with the Nehu Council?
Mr. Suvir Sen, I believe, is the counsel for Nehu. I don't see him also. Since it would not prejudice them in any manner.
But we're not going to go.
Yes,
to that
true.
right now. Please take a fixed date.
Then,
After 2 weeks.
no, but then I won't be free. That's the whole difficulty.
Then you can appear virtually.
My Lord, October, we don't have puja vacation here, I suppose. Do we
We
have?
have very limited puja vacation. It's only from the 7th to the 11th.
So, my Lord, can we have it on 15th of October?
15th, yes.
15th October?
Right.
Very well, my Lord.
Due to prayers, we have respondent number.
6, Your Lordship.
6 was to be in bereavement for some accommodation stuff. Reservations have been raised. Oh, we won't record that. Just a matter on 15.
My young friend is trying to tell me that no further adjournment. I said, if again another bereavement comes, then my lord again will be compelled.
It might,
Who knows?
Yes. Right.
Highly obliged, Your Lordship.
May it please, Your Lordship. I beg to mention item number 21. Your Lordship, I'm praying for some accommodation in this matter, Your Lordship.
My lord, I have no objections.
What's the matter about it?
That electrocution matter, my lord. Electrocution matter.
Oh. The legally counsel? No.
No, Your Lordship.
When?
After 2 weeks.
Okay.
Deeply obliged. And my lord, a similar prayer for item number 28.
20?
28, my lord. Item 20.
Yes.
My lord, can you have the matter after 2 weeks, my lord, because the conducting counsel, Mr. A.H. Kamalang, is in its post. I seek consent of the opposite party.
1 week, okay.
Deeply obliged.
May it please, Your Lordship, I beg to mention item number 18 and 19.
What happened? Where's Mr. Philemon?
This matter is being conducted by Mr. Paul Pascal, Your Lordship. Kindly have this
What's the
matter.
reason?
Personal difficulty, Your Lordship.
You conducted now?
I don't have the briefs, Your Lordship.
You're not?
The briefs are with Mr. Paul Pascal, Your Lordship.
You're not the?
I'm mentioning this matter on his behalf, Your Lordship.
Your Lordship, I'm appearing on behalf of respondent for Your Lordship. No objection, Your Lordship.
No objection.
Okay, after 1 week, yes, please, 22 matters, right?
Similar prayer from item number 27, Your Lordship.
For my. Is Pascal here also?
No, Your Lordship.
And this is, who's the arguing counsel here?
Mr. Philemon Nombi is arguing counsel, Your Lordship. Kindly have this matter after 2 weeks.
Okay. Yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 33. Your Lordship, the rejoinder was filed on the last date, so we're seeking some clarification from the department in this matter, Your Lordship.
Okay, the method in assembly on behalf of the state respondents submits that as the rejoinder has been received, some instructions necessary. Stop. She prays for last 2 weeks time. Just after 2 weeks, yes.
Obliged, Your Lordship.
Yes. Anything else?
Lordship, I beg to mention item number 26, Lordship.
Where's Mr. Dingo?
It's not keeping well.
You conduct the matter. It's been hanging.
But the arguing counsel is senior counsel. Arguing counsel is Mr. Dingdor.
When do you want him?
2
When
weeks.
did he recover? He's gone back for checkup.
Today he's gone back to check up.
Yes. When?
2 weeks.
Mechanical, yes, 2 weeks.
Your Lordship, similar prayer for item number 22.
What similar prayer?
Your Lordship, the conducting counsel is not keeping well, Your Lordship, so I pray this matter could be adjourned for 2 weeks.
You're for the petitioner? Who's for the petitioner?
I have taken the concern, Your Lordship.
You have any objection?
No objection, Your Lordship.
There's no urgency? Okay, 1 week is 2 weeks, okay.
Your Lordship, I'm appearing on behalf of Dr. P. Agarwal for UGC, Your Lordship.
Yes.
Highly obliged.
Similar prayer for item number 34, Your Lordship.
How many? The whole list is gone now. Why 34? Where's Ms. Jindal?
Lordship is not keeping well.
Where's Mr. Kurishi?
He's there also.
He's there. You have objection?
No objection.
3 weeks, yes.
We are for the state respondent.
No urgency, let it be.
Yeah, please, Your Lordship.
Yes.
I beg to mention item 32.
30,
32.
Malcolm Star.
Yes, Lordship. I'm praying that this matter may come
Where's
after
the
2
ratio?
weeks.
Doesn't come back.
Lordship is, I'm praying for some accommodation for today since having one part heard matter in court room number 3,
Please?
Lordship. Since the senior counsel is having one part heard matter in court room number 3.
Just regarding creation of new village, Lordship. Yes.
Who is the main respondents in this matter?
The village, Lordship, the parent village, the district council and the...
You are the parent village or you are the
Lordship, they are
newly
the,
created village?
Lordship, they are the clan members, Lordship.
What clan?
Maunai clan.
Oh, the Dingdong Maunai clan.
Lordship.
Okay, 1 week, yes.
Lordship. Please, Lordship. I beg to make a mention for item 20, Lordship.
Number?
20, Lordship.
20?
Yes, Lordship.
Some items are remaining minutes, but adjournment.
Is the Lordship.
Oh, yes.
I'm appearing on behalf of the petition, Your Lordship.
You're objecting.
They have informed us already, Your Lordship, so no objection, Your Lordship.
When?
So 2 weeks, Lordship.
Mr. Bowman.
Much obliged, Lordship.
Similar prayer for item 35 as well, Lordship. 5, Lordship.
Last right.
Okay, list after 3 weeks, 35.
Lordship.
What about 31? Don't know time. Who's appearing?
Your Lordship,
29, 30?
Your Lordship, I beg to mention item number 17. Kindly let this matter come after 2 weeks.
Who's behalf? What's the matter about?
It's about service matter, Your Lordship, pertaining to
22 matter, service matter. What? Where was the Guru?
He's having long hearings today.
They have long hearings today. Then they don't give precedence to the first court in the court. 1 week is really bad. So do you want us to adopt a new format? We won't give weeklies anymore. We'll give 10 lists, 10 matters the day before, no adjournment for those. Only on extenuating circumstances. So we'll prepare also and then lawyer prepare also. I think it's better that way. What do you say, Mr. Deb? Mr. Day? It's better we just post 5 matters a day, for hearing. And those matters will be taken up, irrespective. No adjournment. Okay. What order will you say?
Your Honor, Your Lordship, I beg to mention item 14, Your Honor.
There's no item left for mentioning.
2 weeks time, 1 week time, Your Honor.
14 you can't mention, it's order matter. So you wait, let the matter be called out.
It's for filing for affidavit, Your Honor.
There's you let the matter be called out for orders, not for hearing. Only hearing matters that we mentioned.
Daily list item number 1.
May I please, Your Lordship? Here, my lord, I am the unmarried daughter of. So I have applied for the family pension, my lord, since I was unmarried. As per the Meghalaya civil service rule, my lord, if my lord peruse rule 48, my lord, clause B, it says unmarried, unwidowed, divorced daughter not covered by the first category above up to the date of marriage or remarriage or till the date she start earning or up to the date of death, whichever is earlier. My lord, let notice be issued, let them file an affidavit. Why it was rejected, my lord?
For 7 and 8, Lordship. What has happened in this case is initially they have submitted papers which was not incomplete. Then we had to resend back to the department. So after the department had sent again the documents to our office, then when after scrutinization of the documents, then this impugned letter came. So I'll seek instruction on that, Lordship.
Third, Mr. SDM and Constitution issue notice. A movement except for the behalf of respondent 1, 2,
126,
146 and 9.
9.
And Mr. Kim Plung is accepting this on behalf of 7A. Offence was complete this after 3 weeks for instructions of affidavit.
Highly obliged. Hello.
Item number 2.
Lordship, as per the last order, we have received the affidavit.
I filed the affidavit.
Where's the affidavit? Authorization.
Filed on 3rd.
At page 6, point number 7.
Page?
Page 6, point number 7. The Darbar has unanimously resolved to authorize Ubraswell Palyar to represent the clan in place of Dolly Palyar. So not as the acting leader, but as a member of the clan.
So what today, what should we do?
Lordship, I pray that the matter be posted for hearing.
My lord, on the last occasion, on the 26th,
We had already vacated the order regarding the status quo with regard to the substation.
Yes.
So nothing remains there regarding that, your part.
MEPDCL, no.
my lord, however, my lord, on the last occasion, we have been just make a party. So this order also, my lord, we have to take instruction of the department. If need be, my lord, we will no longer contest.
No, but see the last order.
My lord, I have seen that.
Last order says what?
My lord, the order is.
Last order says, where's that?
You can proceed with the construction.
My lord, that is our grievance only that we have not been allowed. We will not contest anymore.
See, this order, then there's contempt, then in the concept view of this court, as well concerns public utility, which is being executed public interest, status quo order lifted, project for to continue. Then,
my
you haven't seen this order.
I have seen, my lord, I have seen the order. But my lord, the order also says that we have been included as respondent number 3 also, my lord. In the
We are?
case. We have been made as respondent number 3 in the miscase matter, my lord. In the miscase which have been disposed of.
So
we are still a party, my lord, in the main case.
they don't want to be party anymore.
My lord, if this order is vacated, our grievance.
Doesn't matter, you be there, suppose you
My lord,
have some other issues to raise later
my
on.
lord, that is what.
There's unnecessary submission. Yet an affidavit has been filed by the on behalf of the
Respondent
number one, showing the authorization to represent the clan, and not only as being the same thing on board. Mr. R. Pays that the matter be taken for hearing, or listen matter for hearing. We'll finish off this matter. Shouldn't keep it pending.
Obliged.
Item number 3.
Your Lordship, I just need some time to file my rejoinder, Your Lordship, from all the respondents.
Okay, it's first time asking.
Last.
You want by affidavit?
Yes,
Your
Your Lordship.
Your Lordship, 3 weeks time may be different.
Rejoinder? No, MS El Panjam. Please without 2 weeks time for rejoinder. Payers allowed.
I know. Similar
3 and
to
4
for
connected, 3 and 4 connected, Your Lordship.
I know.
Item number 5.
Well, in this matter, they are yet to comply with the order of this honorable court, my lord.
May I please,
Who's appearing here?
Your Lordship, I beg to submit that, Your Lordship, on behalf of respondent number 5, I filed Okalatnama on last date, but I could not appear on that day, Your Lordship, because he returned in 2018 before the cause of action for the case arose. So, my prayer before Your Lordship to delete the name of the respondent number 4. Because
Can you kindly file a application striking off?
because I have pension paper is also there.
You kindly file a petition striking off. Yes, MS
Yes,
only.
For the
You are appearing for 1, 2, and 3.
state, not sure, state, 5, delivery state.
Last order, you asked for 3 weeks time. They are in the process of compliance with the order.
Yes, madam. Advocate General is dealing this matter.
Where the Advocate General?
My lord,
There
we
is
are
there, I
in
can
the
see his
process
name
of-
there.
My lord, since we have already admitted that we are in the process of considering the petitioner's case. However, my lord, we require time because there is a number of other cases of regularization which has to be looked into, my lord. Which is why last occasion also, my lord, we have admittedly stated that the entire issue is under process. But the only difficulty is we need time, my lord.
6 weeks time was given, my lord. In the last occasion, my lord, 6 weeks time was
Correct,
given.
my lord. It's 6 weeks time, my lord. But then this is not only confined to the petitioner here, my lord. There are a number of employees who are to be looked into, my lord. So this cannot be done only for one specific person. The entire, my lord, employees who are.
That means you're in contempt.
So, my lord, we have to. But then we
You
have
have to.
admitted.
You have to be in contempt. I mean.
My lord, we'll find out our affidavit, my lord, the reason for.
See, the thing is that this is not the first round of litigation. He's come here 2019.
For the fourth time, my lord.
My lord, we need time. Kindly consider, my lord.
Just being submissions or being submissions
No, my lord, we
without
are
proper
in touch with the
instructions will not
department.
work.
We are in touch with the department and we need time, my lord. That is the only difficulty with the department concern also.
MSR only today has expressed a difficulty. Expressed difficulty, correct?
My lord, as of
In
now,
obtaining instructions.
because my lord, we don't have it.
Appearance, huh?
It's a verbal instruction, my lord. We have received from the
It
department.
doesn't work that way. It's a contempt.
My lord, give us some. 2
Unless
weeks
you
time,
make
we'll
officers
give
stand
you an
here again,
affidavit, my
I
lord.
think contempt orders is put. I mean, the orders will be
But my
taken
lord, the last
seriously.
order we have admitted that it's under process, my lord. The only thing
Admission and action, two different things.
my lord, these are.
I admit that I owe you 10 rupees, but I won't pay.
No, my lord, we are
The amount
paying.
of
We
that.
will pay him, my lord.
Is it the same thing like that?
We will pay him, but we need time.
You are
to
telling,
the complete
you're
entire
telling
process.
Mr. Deb, okay, I owe you 10 rupees, but sorry.
Oh, my lord, we will pay him, my lord, what he deserves.
MS Arconi on behalf of the respondents 1, 2, and 3 has prayed for further 2 weeks' time to obtain specific instructions with regard to compliance of the order dated.
Order dated 9/3/2024, my lord.
90,000. Praise the Lord. The expected next day, specific instructions are received or accurate file.
Well, 19/3, I'm correct.
93, pending which further orders will follow.
May I please, your lordship, my name may be recorded against the respondent number.
Application Saji has entered appearance on behalf of the respondent number 4 and submits that before the cause of action arose in the matter, the said respondent number 4 had already retired. When did he retire?
February 2018.
He is permitted to file an appropriate application for striking off the name of respondent number 4.
Much obliged, your lordship.
Item number 6.
May it please your lordship. Lordship, in this matter, we have filed the affidavit. This matter can be posted for hearing.
Your lordship, we have received the affidavit filed by the respondent, and as per the affidavit, your lordship, this matter can be disposed of, your lordship. Since, if I may take your lordship to page 5.17 of the affidavit, your lordship.
What's the matter about?
It's about delay in releasing my pensionary benefits, your lordship.
Para 7?
17, your lordship, page 5.
Yes.
The pension papers has already been forwarded to the Account General for necessary action and disbursement of pensionary benefits
This
to
is
the
appearing
petitioner.
for the AG? Just now, the other party?
The AG is not made a party
Now
today.
you're a party. And how do you bind them to process your papers within a certain period of time? If they already submitted all the requirements to the Accountant General's office. What's BATC? Border areas.
Yes, your lordship.
Point number 5. Anyway, we'll dispose it of then.
No, lordship, but however, it is to be stated that the petitioner
Yes.
has not complied with certain directions. There were certain directions which has been passed in Annexure 8 of this affidavit, lordship. There's an order that has been passed stating that
See Annexure 1. Yeah, this is August 22nd, August, very recent letter. Only pension people in respect of so-and-so. With reference subject, please find enclosed here the following pension papers and all connected papers respect of the petitioner for fair information necessary action at your end. This was sent by the director to the principal accountant general. In this regard, certified no provisional pension has been drawn petitioner. Moreover, no outstanding dues lying against him. Further, the petitioner willing to apply for commutation of pension after so and so. Right?
Yes.
Then,
Lordship,
and then after that, on 22nd, on the same date itself, sanctions of quarter expenditure of so and so, cash payment of leave salary, earned leave, so and so forth. Then, what remains?
The leave encashment has been received, Your Lordship.
You received.
Yes,
There were certain papers that
What certain papers?
Yes, Lordship. It has been in Annexure 8 of this affidavit.
Annexure 8?
Yes.
8?
Yes.
You have put Annexure 8?
Annexure 8, Lordship.
What do you mean by Annexure 8? There's only one or two annexures.
Only two annexure.
Lordship, there's according to order dated 26.
What annexure? Tell the court.
The annexure, it seems, has not been annexed.
Then you're asking the court to go materials not placed before it.
No.
You're a young lawyer, you prepare it carefully.
I have the order with me, Your Lordship, for use it.
That's not a kind of submission to make. If after it has been filed by the respondent before we go by what you've been based on the report.
Let it be posted for hearing for the next day, Lordship.
Are you appearing the case or someone else?
Yes, Lordship, I'm appearing.
You're a government advocate.
Yes, Lordship.
Listed after 1 week in order column for necessary orders. You correct your whatever is necessary. We're not saying anything.
Item number 7.
Highly applied.
My lord, I'm praying for 3 weeks time, further 3 weeks time.
For what?
For submission of my rejoinder.
You already been granted time?
Yes, my lord. This time we'll file, my lord.
Okay, you're Mr.
I'm P. Ghosh, my lord.
B. Kaushik.
P. Ghosh. P. Ghosh.
Also praise us aloud. Further 2 weeks time.
3 weeks.
3 weeks time for join. Here's the draft.
8 also.
Same.
Yeah. Yes, my lord.
Much more.
Obliged. Yeah.
Item number 9.
Settle the matter.
Your Lordship, we need some more time, Your Lordship. We have come up with some terms and conditions from our side, and it's pending acceptance from the petitioner side.
That's correct.
It's correct, Lordship.
Here in this case, Lordship, because of the dispute between the petitioner and the respondent number 4, Lordship, the work got stalled, Lordship.
What
Because
was
I could not execute the work, Lordship, because there is a time frame, Lordship, given
For a
in
school.
the work order, Lordship, yes. If the dispute continues, Lordship, then there is all likelihood that my work order will be cancelled, Lordship.
Who are you? Also, you're a contractor.
Yes, Lordship. So I have received the communication letter, Lordship. I'll just place my. Because this is a project for the benefits of the students, Lordship. Now, after the execution of the gift deed, the property.
How much has the construction progress?
Progress, Lordship.
Not yet, Your Lordship. We have not started.
That is why, Lordship, I have received a letter from the
National Education Society. They are sponsoring the project.
No, Lordship. This is the Manipur Industrial Development Corporation.
Government of India project. Who's paying for the project? Ministry of Tribal
Manipur.
Affairs.
Manipur, Lordship.
Manipur is the agency.
Industrial Development Corporation.
They are the
Limited.
agency only that to.
Name is given by that national, yes. Ministry of, yes.
Central of Tribal Affairs.
That is the one. That is the project, Lordship. My Lord, para 1 and last para, Lordship. para 1 and last para.
Does not specify your project only.
Lordship, here I have not even started Lordship, because the time frame is for 18 and 20.
What is the value of the contract? And how long is it supposed to take?
18 months, Lordship.
As per, and what's the value?
24 months. Notice.
You're a contractor, you don't have the idea about the value.
Lordship, Annexure 9 is the work order, Lordship.
Annexure 9 of the writ petition.
My lord, let the settlement process be go on. In the meantime, I may be allowed to start the work, Lordship.
Your Lordship, in this matter, we are about to come to the final.
You can't hold this whole project to ransom also, Mr. Jirwa.
Yes.
And today is the meeting.
Suggestion, Your Lordship.
Start when?
Your Lordship would like to make a suggestion.
When are you supposed to start the project?
After the execution of the work, Lordship, because the work order was issued February 2024, Lordship.
So now already lost.
Northeast is 24 months, Lordship. For plain area,
24 months.
Yes, 24 months.
Lordship, this project is for a public project, Lordship.
Of course.
Lordship.
At least I may be allowed to.
Let him start.
Yes, Lordship.
Subject settlement talks.
Your Lordship, just a suggestion, Your Lordship. If this matter, like pending this incident writ petition, Your Lordship, if any development comes up between the petitioner and myself with regard to the settlement, then we can give the NOC at any point of time, Your Lordship.
Let him start.
Because we are at the verge of
banging your heads
with
against each other,
finalizing
matter.
terms and conditions.
Lordship, the settlement as
Is
well.
the project of public utility.
Yes, Lordship. Otherwise, there is no likelihood that they will
See,
cancel.
Mr. Jirwa, one public interest is
It's public interest.
Public
No,
interest.
public interest, Your Lordship, we understand, but it's a
Now it's
private
personal
property
interest
that we are concerning.
Because of the
Lordship.
private
This is not a case where the government have acquired the land. This is given free of cost by the petitioner, Your Lordship, when they were claiming that the land belongs to them. But now we are saying, no, the land does not belong to them, but it belongs to me. And the suit is also pending, Your Lordship.
What's the size of the land?
With regard to the school, Your Honor, or with the entire plot?
School.
With regard to the school, it's 18 acres.
20 acres.
Entire plot?
And the entire plot is close to 800 hectares, Your Lordship. So considering the size of the land, Your Lordship, we are taking
So
some
that
time.
part, if we have 800 hectares claim, give the 20 acres.
Your Lordship, I don't have instruction as of
You
now to
excise
say
that,
yes.
you cut it out from that, your larger dispute.
Your Lordship, with regard to that suggestion, Your Lordship, if this pending this matter,
Who's
Your Lordship,
representing this, Imam Nokha?
I'm representing, Lordship.
No, I mean like in person, in negotiations. Himself.
In the agreement, Lordship?
No, you're saying having settlement talks.
Oh yes, himself.
The CM and the
village Darbar Shnong,
the village Darbar, Lordship.
represented by the headman, Your Lordship. But they are the parties from the other side.
So you see it's village land.
They are saying it's village land,
And you're saying it's
whereas I'm saying it's my land because I have put the documents.
What?
Your Lordship.
Who are you? I mean like.
It's a
what land?
self-acquired property, self-acquired property of my mother. And we have a document, it's a registered documents also we have. That's why, Your Lordship, when the matter was before the DC to discuss the matter, the DC did not give the green signal for the project to start, because why? You have seen that we have all the relevant documents. But instead of settling the matter with us after they have come before so. My Lord, I'm appearing for the state.
Then when was the project identified and sent there to this particular place?
My Lord?
When was the project identified and again? Because it's Eglihawa school, right?
My Lord, it was way back in 2014, my Lord.
So the donation was 2014.
This project, as per the agreement, Your Lordship, they have executed an agreement to start the school in the year 2020, Your Lordship.
My Lord, the agreement is
Not
in the
2014.
petition, my Lord.
2014 is for, that's what, Your Lordship, if you go on merits, Your Lordship, this matter will not even sustain, Your Lordship.
My Lord, the
Because they are
agreement-
filed a different
The
document
agreement
saying
which
that it was an
executed with
document
the
for this
State
school.
Department, my Lord, is at Annexure 1, my Lord, and the agreement says 2014, my Lord.
So this is not eklavya. If the language of the agreement be read out, Your Lordship, Your Lordship will have a... And this school is now at Lauburton, Your Lordship. It has been shifted to another location. And there's an RTI report also, Your Lordship, that I have filed.
Annexure 1, my Lord.
If I may submit, Lordship. Lordship, whatever dispute is there between the petitioner and the respondent number 4, Lordship, we can settle that outside court, Lordship. But so far as this matter is concerned, Lordship, disregard.
That, so the thing is that if the public is suffering, then let them take the project somewhere else where people give land.
Just 1 week's time may be given, Your Lordship. It's just for the petitioner to consider, Your Lordship. Lordship, what I pray, Lordship, whatever may be, that will not create any hindrance for the settlement of the parties, Lordship. At least I may be allowed to start the work, Lordship. Because I have received the letter today also. Today is the meeting.
And the settlement is at the final stage, Lordship. We positive that a settlement will be arrived.
1 week's time will be given.
You're not willing to part with 20 acres.
Pardon, Your Lordship. No, it's with regard to the terms and conditions, Your Lordship. We are not denying, Your Lordship, or refusing to accept this project, Your Lordship. We want to, but then when it comes to the terms and conditions, Your Lordship, we just want that this land is to be to come in that terms and condition, not separate. So to finalize that, Your Lordship, maybe another 1 week's time may be given. Or like I've suggested, Your Lordship, pending this
So
petition.
you mean to say that the agreement was made, the donation was made different plot of land, and the school is being concerned different plot?
The 2014, Your Lordship, 2014.
It's a different plot.
It's a different school altogether, which was proposed to be constructed in my land. And that too, the same way that they have done. They have executed an agreement with the state
agreement
government.
also was to be in your land.
It was in my land.
Second one also.
And then we filed a suit and we got the injunction. And then after the injunction, the school was shifted to another place. So again, in the year 2020, they are repeating the same thing. So instead of settling the matter between us or wait for the court's order, they just went behind our backs in the year 2020 and executed an agreement with the state government for this project.
Lordship, so far as the suit is concerned, the suit has been withdrawn, Lordship.
No, the suit is pending now.
In the year 2020, Lordship. It was withdrawn by them.
It withdrawn to file afresh because there are some defect, but we have revived
After 2020 withdrew the suit, when did you reinstitute it?
We withdrew last year, Your Lordship, 2023, and we instituted
You filed a
again.
fresh one now?
Yes.
You got injunction again?
No, Your Honor, there's no injunction for this present suit because this talk of settlement is going on, Your Lordship. Even there's no movement in the suit as well.
I think you can't settle then.
This matter will be settled, Your
We're
Lordship.
looking at the larger interest, Lordship, for the interest of the students, Lordship. The welfare of this.
You can't just go and give away land also.
Lordship, we're settling that with the respondent, Lordship.
Go and give away and say yes for public interest. Like I'll give away Mr. A's property.
Lordship, that is the terms that we're working the terms and conditions with the respondent, Lordship.
What terms and conditions? They've been deprived of valuable right also. If it has the land.
Lordship, that's why there's a settlement, Lordship.
Now you maintain that it's your. It's belongs to the HIMA.
Lordship, it belongs.
Intention in the suit.
Lordship, now we cannot go to whom it belongs, Lordship. Now we're in a settlement process is going on, Lordship. Let us finish with the settlement, Lordship. They're positive about it, Lordship.
We'll give you 1 week's time then.
1 week's time will be good enough. It depends on the petitioner because from our side we have given the terms and conditions.
1 week time because we don't want to prolong also, Lordship, because
Yes,
we understand the interests of the students.
So, the parties counsel for the petitioner and respondent number
6.
6 were the main contesting parties. Pray that it be given as talk settlement is still underway. Pray them be given some more time to settle the issue.
However, pending
also
this
submitted that in all likelihood the same will result in a positive outcome.
Lordship.
So that the project as envisaged and sanctioned by the state respondents, which is for public interest, not be affected. So on this undertaking, let the matter appear after 2 weeks. It's expected that before the next date, the settlement should have been worked out. With regard to Mr. S.A. Sheikh, Learned Counsel for Respondent number 5, who is the contractor who has been engaged to execute the project, has expressed his misgivings and has also produced a letter dated 5/9/2024
and 6/9 and 6/9.
Yes, and 6/9, whereby the non-starting the project has been flagged by the Ministry of Tribal Affairs. In this view of the matter, next paragraph, in this view of the matter, as there's some urgency, 26. And then listed on exactly after 2 weeks.
May I pray for 1 week, Lordship, because in the matter, if the matter is settled, because my Lord, I have apprised my Lord, because
Lordship, I'm praying for 1 week's time. Lordship. Only 1 week's time.
I will be the chaperone.
1 week time.
Not 1 week.
1 week.
1 week time.
Yeah, that's for 1 week.
Item number 10.
You make a condition like you do whenever a project to give employment to your family members.
Your Lordship, that is also, that representation is pending with the state. We have already made that, so.
Much obliged.
Much obliged.
May please, Your Lordship. Lordship, I'm praying for a week's time to file my rejoinder, Your Lordship.
We'll sit for hearing. Let the matter for hearing in usual course. Rejoinder to be filed in the meanwhile.
Much obliged. 11.
Please, Lordship, I have filed my affidavit, Lordship, this month.
What about 1 and 2? They
1 and 2.
They have not appeared.
Not received back. How come you said they've been served?
No, Your Lordship, we have already filed
Where's the affidavit? But the officer report says that it's been returned.
No, Your Lordship.
When did you file a service affidavit first? Office notice.
The file on the 21st August.
Yes. This matter regarding?
Regarding, we have
Issuance of DLH certificate, Lordship. Their prayer is for direction to issue the correct mark sheet and DLH certificate.
When did you file affidavit? It's been filed. You filed a joinder?
No, Your Lordship, we will
You
not
won't
file.
file a joinder.
We won't file it.
Yes. Also said like submits that no joinder will be filed to the affidavits filed by the respondent number 3, 4, and 5. Stop. With regard to service on the respondents number 1 and 2, though an affidavit indicating service has been filed, the office note has been filed on 21/8/2024. Formal office note dated 9/9/2024, however, indicates otherwise. Stop. Petitioner is permitted to take fresh steps on the said respondents. To take fresh steps, I think went to the wrong hands. Just after 2 weeks.
That's it.
12.
Lordship,
Yes.
the respondent was to file their affidavit, but they have not filed and as directed by your Lordship. But they have not filed it yet.
Lordship, so far 244 is concerned. Lordship, kindly accommodate another 10 days time.
4 or 244?
24. 224, sorry. Lordship. So we just...
We'll dispose it of. Mr. Khanot remains.
Lordship, both of them.
There are two matters. Lordship, the second matter, there was an interim order passed and we had passed...
You have no objection if they go somewhere else?
No.
It's a grade A, what class 1 site?
224, Lordship, slightly, we would just like to bring an affidavit on record.
So, Lordship, both the matters may be taken up together. Let it be fixed on the 16th, Lordship. It's not inconvenient.
And after affidavit can be disposed of subject to them.
That's okay, Khan. On behalf of the respondent number...
There are two respondents only. So, Indian Oil Corporation.
On behalf of the respondents, praise without further time to file affidavit. Stop. Praise allowed just on 16th October. October?
No, Lordship, this month.
For this month?
September.
16th September.
Can
be done?
Lordship, slightly because ensuing holidays. Ensuing holidays are coming. Lordship, at least we need 10 days time, Lordship, because it's still
after 10 days time.
10 days.
It is also provided that if the affidavit is not on board, the matters will be taken up for disposal.
Lordship.
On that date is this next
Oh,
matter.
Lordship, a date. Lordship, a date may be fixed.
10 days hence.
10 days.
10 days. Then what is the date?
Now
date.
Today's 10th, Tuesday, Monday.
10th will be a...
So we are on 16th. 16th is all right.
16 is just 6 days. So we'll have on 23rd.
23rd.
24th. Okay.
Your
23rd.
Lordship,
Yes.
23rd is a little inconvenient. Your Lordship, it's on
Yes.
on the 3rd of October, Lordship.
On the
3rd of October.
3rd of October, Lordship.
That's right. Matter
You're more than 10 days. Mr. Khan has more than 10 days now.
Yes.
14.
And Lordship, so for 30, sorry, small submission, Lordship. So for 13 is concerned, on 23rd August, Lordship, we are asked for a week's time, we are filed an affidavit. There was some problem in the format. So we brought and recorded, Lordship, we have recalled the order.
The next matter.
13.
We'll record it next day.
Next, on, let me take it up on 3rd.
Together, absolutely.
14.
My lord.
Where's the affidavit?
My lord, I am praying for 2 more weeks. Some documents are yet to come, my lord.
After you said that the issue in question is very short,
Yes,
and
my
it can be settled by small
yes.
affidavit.
Yes, my lord. Short affidavit, my lord, showing that my village pre-existed before, even before the Act of 1991, my lord.
Yes.
So those documents I've asked for, my lord, they'll be bringing. So I'll just put on record those, my lord.
Yes. What about number 5? You're appearing for?
2 weeks, same opinion, responding number 5.
Yes. You're not filing affidavit. You file one file affidavit also.
Filing.
1 to 4 not filing.
Affidavit. Yes, Mr. P. Ubin for 6 and 7, and the C. Karyam, for the 2 weeks time for affidavit. Is that after?
Obliged.
15.
Your Lordship, I'm praying for some time in this matter, Your Lordship. We're awaiting instruction.
Legally it matter?
My lord.
What's the matter about?
It's non-payment of salary, my lord. The petitioner has not been paid for
What
that.
about 4 and 5? You're paying fees. Who are the respondents?
For 4 and 5, Lordship.
Who are the respondents 4 and 5?
The managing committee of the school.
You're not paying a salary?
My lord.
Why?
It's not correct, Lordship. I'll file my affidavit, Lordship, in 2 weeks' time.
Since when you have been paid a salary?
My lord, since the year, my lord, 2004 till date, my lord.
2004 till date?
My lord.
Then were you ever employed in the school?
She has been working as a head teacher, my lord.
She's not a permanent.
Then file an affidavit.
I'll file my.
As spread will be time as in 21 to 3 and no period 4 to 5. For the 2 week time, 2 weeks time granted for affidavit. Is there okay?
Obliged, Your Lordship.
16.
Would the respondent were required to file the affidavit, my lord?
No, first your office note not complete, and the office indicates that incomplete address. The same boxing matter?
Yes, my lord.
Not karate matter, it's taekwondo.
It's a boxing matter, my lord.
How is it complete when they give the correct address?
In fact, this address, my lord, finds mention in all the website also.
Let's see. Can you serve a private notice?
We'll make an attempt, my lord. Can you allow?
You serve in your own capacity.
We'll do that.
Yes, though fresh addresses are provided by the petitioner with regard to respondents 3 and 4 The same have been returned again by the Postal Department, citing incomplete address stub. Accordingly, Mr. S. Thapa praise funds allowed to effect private notice upon the said respondents and to file factum of service before this court. Yes, what about you?
Lord, as far as state is concerned, because main grievance is against the association, my lord. However, we have still sent for instructions. We have still sent for sort for pairwise comments.
Help this petitioner.
Lord, we've sent for pairwise comments from the department.
Yes, Mr. Security, on behalf of respondents 1 to 2, also praise allowed to obtain for the fresh instructions. Accordingly, this matter after 2 weeks for the orders. You can you can take these back. These two envelopes. Yes.
Hearing, item 24.
John, minute. It's
29.
May it please, Lordship.
Yes, you have to argue.
Only thing, one short point, my lord, your lordship has posed a query as to whether the principle of natural justice would be applicable in contractual matters or not.
Right.
Your lordship posed that query.
Very good. Yes, I remember that point.
Your lordship has posed that query. Only a brief 2-3 points, my lord.
Yes.
First judgment, my lord, on that point I am relying is 2023.
1 second.
SEC online.
Yes. Wait 1 second. 2020. Yes, with the judgment.
My colleague, 2023 SEC online SC 671. Please give a copy to Learned Senior Bouquet also.
Page?
Page, my lord, is paragraph 54, my lord. Straight away,
Okay.
paragraph 54.
Paragraph 54, okay.
Yes, my lord. Paragraph 54, my lord. May I read? As
Yes.
observed by this
Yes.
court in Jagdish Mandal versus State of Odisha, reported in 2007, 14 SCC 517, that while invoking power of judicial review in matters as to tenders or award of contract, certain special features should be borne in mind that evaluation of tenders and awarding of contract are essentially commercial functions, and principles of equity and natural justice stay at a distance in such matters. If the decision relating to award of contract is bona fide, the public courts will not interfere by exercising power of judicial review, even if procedural aberration or error in assessment or prejudice to a tenderer is made out. Power of judicial review will not be invoked to protect private interest at the cost of public interest or to decide contractual disputes. My lord, if I can place paragraph 52 onwards, but paragraph, because consideration has started from paragraph 48, my lord. Analysis, this 48. This court, being the guardian of fundamental rights, is duty bound to interfere when there is arbitrariness, irrationality, malafide, and bias. However, this court has cautioned time and again that courts should exercise a lot of restraint while exercising their power of judicial review in contractual or commercial matters. This court is normally loath to interfere in contractual matters unless a clear-cut case of arbitrariness or malafides or bias or irrationality is made out. One must remember that today, many public sector undertakings compete with the private industry. Contracts entered into between the private parties are not subject to scrutiny under writ jurisdiction. No doubt the bodies which are stayed within the meaning of Article 12 of the Constitution are bound to act fairly and are amenable to rejudiction of superior court, but this discretionary power must be exercised with great deal of restraint and caution. The court must realize that their limitation and the havoc which needless interference in commercial matters can cause. In contracts involving technical issues, the court should be even more reluctant because most of us judges in ropes do not have the necessary expertise to adjudicate upon technical issues beyond our domain. The court should not use a magnifying glass while scanning the tender and make every small mistake appear to be big blunder. In fact, courts must give fair play in the joints to the government and public sector undertaking in matters of contract. Court must not interfere where such interference will cause unnecessary loss to public exchequer, my lord. So this is I'm relying on paragraph 48 and 52, my lord, to buttress my point that the principle of natural justice is and equity are to be maintained at a distance, my lord. That line is there in paragraph 52, my lord. Should be at then, my lord, kindly see the next judgment is 1989 2 SCC 116. And paragraph 22 of this judgment, my lord.
1 second.
21 and 22, my lord.
1989 to SCC.
1989 2
Yes.
SCC 116.
Paras?
Para 21 and 22, my lord.
Yes.
This finding in our view is not correct in the light of facts and circumstances of this case because in Ramana Dayaram Shetty case, there was no concluded contract as in this case. Even considering that BDA has the trapping of a state or would be comprehended in other authorities for the purpose of Article 12 of the Constitution, while determining price of the house flats constructed by it and the rate of monthly installment to be paid, the authority or its agent after entering into field of ordinary contract acts purely in its executive capacity. Thereafter, relations are no longer governed by constitutional provisions, but legally valid contract, which determines the right and obligation of the parties inter se. In this respect, that they can be claims, they can only claim rights conferred upon them by contract in the absence of any statutory obligation on the part of the authority in the said contractual field. 22, my lord. There is a line of decision where the contract entered into between the state and person agreed with non-statutory and purely contractual, and rights are governed only by terms of contract. No writ or order can be sued under Article 226 of the Constitution of India so as to compel the authorities to remediate breach of contract, pure and simple. Radhakrishna Agrawal versus State of Bihar, Premji Bhai versus Parmar, Delhi Development Authority, and DFO Biswanath Company, my lord. 23. In view of the authoritative judicial pronouncement of this court in the series of cases dealing with the scope of interference of High Court while exercising its writ jurisdiction under 226 of the Constitution of India, in case of non-statutory concluded contract like the one in hand, we are constrained to hold that High Court in the present case has gone wrong in its finding that there is a arbitrariness and unreasonableness on the part of appellant herein in increasing the cost of houses flats and the rate of monthly installments and giving directions, my lord. Now, my lord, kindly see the Jagdish Mandal, which was referred by the recent judgment of the Honorable Supreme Court, 2007, 14 SCC, page 517, authored by Justice Ravindran, my lord.
That was Ravindran. Is it this?
Yes, my lord.
Which?
This is 2007, 14 SCC 517. Lordship would recall that this is the judgment which was referred by the two judges bench, my lord, in 2023 SCC online 671, paragraph 54, my lord. This is the judgment which was relied and referred to by the subsequent judgment also, my lord. Jagdish Mandal, citation is 2007, 14 SCC 517, paragraph 17 onwards, my lord. Kindly see 17. And Direct paragraph on principle of natural justice is para 22 million. The learned paragraph 17 million at page
17.
17 at page
1 second.
526, 17 at 526 million.
Yes.
The learned counsel for the
Calculation.
appellant.
Yes.
Yes, Milord. Question for consideration. The learned counsel for the appellant submitted that the scope of interference in judicial review of tender processes and award of contract is limited only to cases where there is a material violation of terms relating to scrutiny and acceptance of tender, or where the decision is initiated either by arbitrariness, irrationality, or malafide, or favoritism. It was contended that as fifth respondent failed to plead or make out any of these grounds in his writ petition, High Court ought not to have interfered with the contracts awarded to the appellant, my lord. And then your lordship will see the paragraph 21 onwards, my lord.
This is a contention. Yes.
Yes, this is the contention which was dealt by in paragraph 21 onwards.
Yes.
The scope of judicial review of award of contracts. We may refer to some of the decisions of this court which have dealt with the scope of judicial review of award of contract. In a Sterling Computers versus MN publication, this court observed, while exercising the power of judicial review in respect of contracts entered into on behalf of the state, the court is concerned primarily as to whether there has been any infirmity in the decision-making process. The court can certainly examine whether decision-making process was reasonable, rational, not arbitrary, and violative of Article 14 of the Constitution. In Tata Cellular versus Union of India, this court referred to the limitations relating to a scope of judicial review of administrative decision and exercise of power in awarding the contract. Thus, the modern trend points to the judicial restraint in administrative action. Court does not sit as a court of appeal but merely reviews the manner in which the decision was made. 3. The court does not have the expertise to correct the administrative action. If a review of the administrative decision is permitted, it will be substituting its own decision without the necessary expertise which itself may be possible. 4. The terms of invitation of tender cannot be open to judicial scrutiny because invitation to tender is in the realm of contract. More often than not, such decisions are not made qualitatively by experts. 5. Government must have freedom of contract. In other words, a fair play in the joint is a necessary concomitant of an administrative body functioning in administrative sphere or quasi-administrative sphere. However, the decision must not only be tested by the application of Wednesday principle of reasonableness, including other facts pointed out above, but must be free from arbitrariness, not affected by bias or actuated by malafide. Quashing decision may impose heavy administrative burden on the administration and lead to increased and unbudgeted expenditure. This court also noted that there are inherent limitations in exercise of power of judicial review of contractual powers. This court also observed the duty to act fairly will vary in extent depending upon nature of cases to which the said principle is sought to be applied. This court held that the state has the right to refuse the lowest or any other tenderer provided it tries to get the best person or best quotation, and the power to choose is not exercised for any collateral purpose or infringement of Article 14. Ronak International versus paragraph 221.3 versus IVR Construction, which deals with the matter in detail, this court held award of a contract, whether it is a private party or by public body or a state, is essentially a commercial transaction. In arriving at a commercial decision, considerations which are of paramount importance are commercial considerations. These would be price at which other side is willing to do the work, whether the goods or services offered are of requisite specification, whether person tendering has the ability to deliver the goods or services as per specification, where large work contracts involving the engagement of substantial manpower requiring specific skills are to be offered. Financial ability of tender to fulfill the requirements of the job is also important. The ability of tender to deliver goods or services or to the work of requisite standard quality. 5. Past experience of tenderer, whether he has successfully completed similar work earlier. Time which will be taken to deliver the goods or services, and often the ability of tenderer to take up the follow action, rectify and defects or give post-contract services. Even when the state or public authority entered into commercial transaction, consideration would prevail in its decision to award the contract to a given party would be the same. However, because state or public authority or agency of the state enter into such contract, there could be in a given case an element of public law or public interest involved in such commercial transaction. What are these public elements? What are these elements of public interest? Public money would be expanded for the purpose of the contract. Goods or services which are being commissioned would be of public purposes such as construction of road, public building, power plants, or other public utilities. The public would be directly interested in timely fulfillment of contracts, so the services become available to public expeditiously. Public would also be interested in quality of work undertaken or goods supplied by tender. Poor quality of work or goods can lead to tremendous public hardship and substantial financial outlay, either in or rectifying the defect or even at times in redoing the entire work, thus involving larger outlay of public money, delaying the availability of services, delay in commissioning the power project, as in present could lead to power shortages, retardation of industrial development, hardship, and general. After discussing all these principles, my lord, paragraph 22, your lordship will state, kindly see paragraph 22.
Yes.
Judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When the power of judicial review is invoked in matters relating to tender or award of contract, certain special features would be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contract are essentially commercial functions. Principle of equity and natural justice stay at a distance, my lord. This is the line your lordship has noticed in paragraph 54 of recent judgment of Supreme Court in 2023, my lord. 2023 SCC on line 671 in paragraph 54, my lord. Principle of equity and natural justice stay at a distance. If the decision relating to award of contract is bona fide, as in public interest, court will not, in exercise of power of judicial review, interfere even if procedural aberration or errors in assessment or prejudice to a tender is made out. Power of judicial review will not be permitted to be invoked to protect private interest at the cost of public interest or to decide contractual dispute. The tender or contractor which is with a grievance can always seek damages in civil court. Attempt by unsuccessful tenderer with imaginary grievances, wounded pride, business rivalry to make the mountains out of the molehill of some technical or procedural violation or some prejudice to self and persuade the courts to interfere by exercising power of judicial review should be resisted. Such interference, either interim or final, may hold up public work for years or delay relief and succor to the thousands and millions and may increase the project cost manifold. Therefore, in a court, before interfering in tender or contractual matters, an exercise of power of judicial review should pose to itself the following questions: whether process adopted or decision made by the authority is malified or intended to favor someone, or whether the process adopted or decision made is so arbitrary and irrational, the court can say decision is such that no responsible authority acting reasonably and in accordance with relevant law could be reached. Whether public interest is affected. If the answers are in the negative, there should be no interference. Article 226, cases involving blacklisting or imposition of penal consequences on tender contract or distribution of state largesses stand on a different footing as they may require a higher degree of fairness in action. Your Lordship has applied this principle in RMSI while giving the judgment. Blacklisting matter, my lord, where higher degree of, your Lordship has applied this last bottom line in RMSI judgment, my lord, involving blacklisting or interposition of penal consequences tender, largesses, and stand on different footing. When it comes to blacklisting, your Lordships have also that it will stand on different footing. Lordship has delivered the judgment 2 days back, my lord. Yesterday, my lord. Yes. Yeah, yes. On this, and there, your Lordship has applied the last bottom principle, my lord, in examining the proportionality and issues, my lord. Now, this same aspect, my lord, I have stated in my counter affidavit only one paragraph I wanted to show, my lord. In paragraph 8 of my counter affidavit, my lord.
Yes.
Para 8 of the counter affidavit, my lord.
Para?
8.
Of the counter?
My lord.
Yes, my lord.
The last counter?
Yes, my lord, in counter in this matter, my lord, this is the counter is in 18 up to 2024, my lord, 18 of 2020, in this matter only.
Filed on 25/7. Oh, no,
Yeah,
sorry.
filed on
You filed on
13/3,
13/3, sorry.
13/3, 13/3, my lord, 13/3.
Para 8.
Para 8, my lord. In state of Gujarat versus Meghji Petrasa Charitable Trust, where a similar writ petition questioning the termination of contract by government authority had been instituted, Honorable Supreme Court was pleased to observe as under. We are unable to see any substance in the argument that termination of arrangement without observing the principle of natural justice is void. The termination is not a quasi-judicial act by any stretch of imagination. Hence, it was not necessary to observe principle of natural justice. It is not also an executive or administrative act to attract the duty to act fairly. It was, as has been repeatedly urged by Mr. Sri Ramaswamy, a matter governed by contract agreement between the parties. If the matter is governed by contract, writ petition is not maintainable since it is a public law remedy and it is not available in private law field where the matter is governed by non-statutory contract. And in this light, my lord, only one letter which my letter at page which is impugned before your lordship is kindly see that letter at page 176, my lord,
Of the writ petition.
of the writ petition, my lord. Paragraph 176, my lord, paragraph 1. I have already placed the judgment regarding the subject title of the matter, my lord, on last date of hearing. I am not repeating that for the sake of brevity, my lord. Page 176, my lord.
Yes.
This is the letter which is impugned before your lordship. Whereas the caption preliminary agreement was executed between
136.
you 176.
176, madam.
Oh, 176. It's 176.
Right.
12.
Got it, yes.
12, madam.
Termination.
I'm sorry, my lord, Annexure 6, my lord, Annexure 6,
Yes,
176.
you got it. The termination letter, 22nd December.
Yes, my lord. Yes, my lord. This is the letter which is impugned before your lordship.
Yes.
With regard to subject, my lord, termination of preliminary agreement, my lord, I have
Yes,
already
got
placed that judgment, my lord. I'm not repeating that part,
Yes.
my lord. Kindly see 1. Whereas the caption preliminary agreement was executed between you and Government of Meghalaya for survey and investigation of Upper Cree so and so on B boot basis. Whereas the total amount of upfront fee required to be paid is 125 lakh, but you have paid only 118.75 lakh, showing a failure to pay the full amount after a gap of more than 10 years. This upfront fee stands forfeited as per clause and 8, my lord. 3, where you have failed to reimburse to the government appropriate state power utility 50% of the amount spent by government on investigation and infrastructural work of the project totaling 145.18 lakh, that is 72.59 lakh as per clause 16 of the preliminary agreement. Second 50% payment has not been made. 4, my lord, whereas clause 9 of the preliminary agreement requires certain milestone to be achieved by you, and you have also failed to achieve the same despite numerous opportunities given to you. 5, where the appraisal report of detailed project report dated 13/12/2015 of the above two projects weighted by MEPGCL showed that projects are not financially viable with a tariff cost of 9.3 kilowatt in Upper Cree Hydro project and 8.18 in the other project, my lord. 6, whereas the terms of clause 12 of the preliminary agreement, it is clearly stated the preliminary agreement shall be valid up to period of 1 month after due date of submission of DPR or signing of implementation agreement, whichever is earlier. In terms of clause 12 of preliminary agreement has to come and end within 1 month of submission of DPR, that is 12/1/2016. Therefore, preliminary agreement is not in existence as of today. 7, whereas in terms of clause 13 of the preliminary agreement, liberty was given to both parties to enter into the implementation agreement only when both the parties are satisfied with techno-economic feasibility of the project. 8. Whereas government is not satisfied with techno-economic feasibility of the agreement, therefore is at liberty not to enter into the implementation agreement. 9. Whereas you have placed the proposal in minutes of the review meeting held on 19 February 22, seeking certain concessions, namely waiver of additional 10% free power to the government offered by you during the bidding process over and above 12% free power to the government as per state power policy. B, to include the development of approach road and other infrastructure facilities other in the state budget to relieve the development from financial burden. C, waive of charges for meteorological data to be paid by developer for receipt of the said data from MEPGCL for formulating the DPR of two projects. D, to take into account additional power that will be generated by downstream existing Umia Mumtru Stage 4 HE project of MEPGCL on account of diversion of upper three ribbon from two projects. To avail soft loan from MIDC against the project since banks are reluctant to extend financial support for hydro project, whereas the said terms and conditions are not acceptable to the government and also amount to post-standard modification and also are not in public interest. Whereas you have also shown complete apathy in pursuing the matter in right earnest, which led to inordinate delay in implementation of project, and you have also failed to attend the review meeting for all projects held on 20th April 2022. Whereas you have raised an artificial, fictitious and bogus claim of 15.4 crore, whereas state has suffered loss on account of your act and omission. You have no basis to make the above claim. Whereas the state is entitled to be compensated for losses caused by you in ordinate delaying the project and submitting defective DPR or not making payment in terms of preliminary agreement. Now, therefore, in view of the above facts and exercise of power under various clauses, various clause 29 of the preliminary agreement, it is reiterated that preliminary agreement is no longer in existence. Said agreement is hereby informed to you by way of the said aspect is hereby informed to you by way of abundant caution. That is further informed that upfront fee paid to you also stand forfeited as per clause 4 and 8 of the preliminary agreement. That is, it is further informed that you are not entitled to claim any further amount on the preliminary agreement arising out in relation to the last preliminary agreement dated 9/5/2000 on the instant case being issued in accordance with preliminary agreement and without prejudice to rights and entitlement in accordance with law. My humble submission based on reading of include letter is it is a purely commercial contract, my lord, and I am squarely covered by the authoritative pronouncement of this court and or the pronouncement of the Honorable Supreme Court in this matter, my lord. And your lordship has seen the prayer at page 20. The prayer in effect is, my lord, direction to the state government to enter into implementation agreement, my lord. And the cogent reasons have been given in the letter of 22nd December 2023, my lord, why government is not inclined to go ahead and enter into implementation agreement, my lord. Kindly see the prayer and I will conclude by showing the prayer, my lord.
Yes.
Paragraph 20, my lord.
Page 20, my lord.
Yes, page 20, you got it.
Page 20, my lord. That this honorable court be pleased to issue writ of certiorari or any other writ or direction in the nature of certiorari, calling upon the papers and proceedings which culminated into issuance of impugned termination order dated 22nd 12/2023, and after examining the legality, validity, propriety thereof, pleased to pass and set aside. B, my lord, be pleased to issue a writ of mandamus commanding the respondent to withdraw the impugned termination notice dated 22nd December 23. Pending the hearing, my lord, then your lordship, this honorable court pleased to stay the effect of implementation of the impugned termination notice, my lord. The impugned termination notice, my lord, what my friend is saying, it does three things, my lord. I classify into three parts. One, it informs that the preliminary agreement has come to an end by efflux of time. Secondly, the impugned letter of 22nd December 2023 also informs, my lord, that the government is not in accord with the provisions or offers made by the petitioner to the government with regard to modification of the terms and conditions of preliminary agreement or future agreement which government or the private parties are negotiating. Third thing the preliminary agreement does, my lord, is that claim and counter claims are there. Government of Meghalaya has certain claims. The petitioner has certain claims. Government is saying that it is entitled to forfeit and plus make further claim also, my lord. So in sum and substance, my lord, the preliminary agreement is nothing but a commercial agreement between the parties, and it has come to an end, my lord. No legal right is there in favor of the petitioner, my lord. It is purely commercial agreement, my lord. And therefore, in my humble submission, writ is not maintainable in view of the long list of authoritative pronouncement of the Honorable Supreme Court, and even this Honorable Court, my lord, has held in number of cases, my lord. This is all I have to submit, my lord.
Yes, thank you. We'll conclude.
I'll just give a reply, because now he brought certain things before the court about because your lordship has said about the principle of natural justice. My learned friend replied with 3 judgments. All the judgments, I knew the judgments he didn't cite. I was prepared with the judgment of Jagdish Mandal. Jagdish Mandal, 2014. Jagdish Mandal, my learned friend relied 2023 for judgment. Tata Motors Limited versus 2023 SSC Online, where para 54 was elite. Para 54 was elite. Para 54, if a lordship looks into it,
para 52.
Sorry, para 50. Para 50
on Tata Motors.
Yes, Tata Motors Limited 2023 SSC Online.
Para 52.
54, 51, 52, 53 and 54. 54 relates to Jagdish Mandal.
Okay.
My lord, I have gone through the judgment. This judgment has nothing connected with the present. These are initial stage when you come to the court. The court said the contract now is between the state largesse. Now a contract is given to Mr. A. Now B comes to the court and saying that no, it should not be awarded to A, it should be awarded to me on this ground. Technically, A is not qualified. So there should not be an award of contract to Mr. A. So all this contract, then the court held that no, why we will deal all this type of contract. There is no question of arbitrariness, no question of principle of natural justice. These are not question of principle of natural justice. It is purely, if you want, because it is at the initial stage. My lord will kindly see, my learned friend is mixing with the proposition of principle of natural justice in connection with our case. What is our case? All this case I will show before this court, my lord. All this kind of case has no relevance with our case.
Okay.
Because if your lordship looks into what he submitted on the last occasion, he said the termination which has been served to us, it's only a communication. It's only a communication. But they have taken a decision earlier because by efflux of time, contract doesn't survive, by efflux of time. Now the reply in this case was that it is not efflux of time. Because on 30/12/2015 was our DPR. Now my learned friend argued that within 1 month time the implementation agreement should have been done. Now I could have very well understood, my lord, no communication. Thereafter you close the case. 19/2/2020 communication. 24/2022 you decided to cancel. Then 9/9/2023 you said that financially is not acceptable because it is too high. And simultaneously after that, when we file a writ petition before this honorable court on 22/12/2023, they decided to terminate this contract. Now, my learned friend has shown one judgment of the Supreme Court on the last occasion, and he argued before the court that this is only it's only a document which you have to go, not the caption, the recital has to be looked into it. Now, I think thankful for learned friend to show that once you go to recital, then it will come automatically. Your lordship has looked into what is a recital. Okay, we are accepting, don't read the caption but the recital. Now your lordship has seen one by one, they have taken a decision. Now what we are on a decision making process of them on 22/12/2023. Decision making process. What decision you have taken on 22/12/2023? All this process, if your lordship kindly look into it, those clauses. I will not read these clauses, my lord, because several times we read, and my learned friend also read several times, at 176, each and every clause, your lordship will indicate what decision they have taken. Now, my lord will kindly look into it. This preliminary agreement has got an inbuilt mechanism. Now again I am repeating, my lord, inbuilt mechanism. I could have very well understood if there was no inbuilt mechanism, then my case would be on a different pedestal altogether. It has got an inbuilt, my learned friend can't deny it. And if that be the case, your termination, where the recital says, this you violated on this ground, then automatically by reading the preliminary agreement, you have to serve a notice to me, which you have not done. Now my learned friend has mistaken saying that no, how do you certain judgment here so I have not come across, I am making it very clear, not on the basis of specific performance of a contract to be invoked, meaning thereby to give the contract to me. No, I am not coming on that. My whole case rests on the principle of natural justice as on date. Because my lord will kindly see on the first read, when we file, my lord, we filed simply on 24/2022, where they decided to cancel, decided. Thereafter, 9/9/2023, where they said your tariff is high. Then they came out Facebook and Twitter, where cabinet has taken a decision, they will again revive this project. On this ground we came. I am telling you very frankly, we had a weaker case at that stage. We had a weaker, let me be very honest confession, my lord, we had a weaker case. Let me put in this way, on the first. But when the termination came to me, then I thought that I don't know what will result. At least some case we can make out now by way of termination. If that termination letter would not have been there, my lord, we had a tough time before this court. That's why I knew at the first stage when your lordship has admitted this case, lot of hesitation, your lordship said, no, go before a civil court, this is why we'll. Thereafter when they terminated, I think that at least some cases made out because by their own letter and by the recital it made it very clear that yes, violation of preliminary agreement. If that be the case, then on principle of natural automatic, that is why the second case is based on the structure of principle of natural justice, violation of principle of natural. I am saying, please don't confuse with my learned friend with specific performance of contract. Section 40, I am aware, what is section 14? My learned friend read, I just rewind his particular, what is the argument. He read 10 and thereafter 14. Your lordship indicated, what is this 14? Why are you reading 10? There is nothing that what do you want to say on the principle of natural justice? That your lordship has pointed out. Now today, my learned friend has come with 3 judgments of this court. Jagdish Mandal, 2014, para 22, scope of judicial review. So to what extent, my lord, NG project, Monte Carlo, all the judgment says the court should not interfere initial. Why the court will look into technicality of how it is settled to A or B?
Yes.
Then it will be, your lordship has to stay away. Earlier we used to trouble the court. Your lordship knows there no technical bit, then court has to interfere in. Now it is too tough because those are the judgments which is very difficult to come up by way of a writ petition. Unless there is some change in this particular by way of judgment by the apex court. Said, don't trouble the court by way of 226. Seek damages. Where is the question of granting a stay? This is not our case. We have gone much ahead of that. Now this is a contract. Now one thing, my lord, your lordship has looked into our case, my lord. What is our case? So, my lord, the argument which is advanced, and I have seen what are the facts of this case. My lord has to look, my lord, the principle has to be looked into the facts of the case. What is the facts? I just marked hurriedly in 2023, this is regarding awarding of the contract at the initial stage. I'll just read one paragraph, para 34. Please don't open, I'll just read it. Otherwise, your lordship will feel boring one after another.
No, it's all right.
Yes, my lord. Sometimes I feel myself bored, my lord, repeating same, my lord. 34, my lord, 1 second, my lord, it is not 34. 33 is by 28 by the petitioner that Mr. Rohatgi, learned senior appearing for so and so relied that the equity relief can be granted to bidder where it has made a material mistake of fact in the bid, and upon discovery of the mistake, he has acted promptly and rectified his mistake. All this rectification of mistake, the event and it is not awarded to him, then he comes to the court, technical bid is defective. These are completely, then the court said, no, we are not interfering it. Don't come with the hands with the principle of natural justice would have been followed. All these facts are different, my lord. You cannot put the proposition of law into the particular facts of the case. So I humbly submit that these all the judgments are not connected with our facts of the case.
So you mean to say that underlying the whole thing, you can just set aside the commercial transaction aspect
now
and come down only that whatever happened, now the preliminary agreement had provided for a certain action to be done a particular way. Now earlier on, okay, fine, if you can say the contract abated and had gone to cold storage, you would have no right.
Yes.
But now, in view of your actions and in view of reviving, the entire dispute.
Yes, you revived.
Yeah, you revived it.
Right, absolutely right, my
So
lord.
once you have revived it, that means I'm entitled.
Yes, you revived.
And whether some right to be heard.
And let us say for a moment that this index.
So notwithstanding the fact that it stems from a commercial transaction, that will be immaterial.
Immaterial. Now, for a moment, let us say that this preliminary agreement doesn't have an inbuilt mechanism. Then your lordship, now your lordship would have taken two views. Either I am entitled to a notice because in absence of those clauses, then your lordship would have taken, no, not required.
Even now also, see, absent the mind of the court is open.
No, yes.
That is the thing. So, we'll have to examine. But the thing is that is, I understand the submissions, that notwithstanding anything else or any other consideration, commercial transaction, the basic facts are that, this happened, which had vested you with certain rights. That's all. By way of the action of the respondents themselves.
Yes, and that you took later.
Words that they have cloaked you with,
Yes, I didn't have. My lord, I had at a time while moving the matter, I thought that it's a difficult case. But when they came out with termination, I thought that now they have come up. That means, number one, their point of delay in laches goes. Number two, the writ is maintainable on the ground because now is a question of natural justice, is now inbuilt mechanism now you have brought, intimated to us. Now, why you have done it? Why you have not? I am asking myself, if your argument, my learned friend argument is contract no longer remains by a flex of time, then there was no question of giving any note. You just finish it off there to 2020, 2022. And all the judgments, my lord, your lordship will look into it, the factual parts of our case, 2022.
But even then, whatever, I'm just...
My lord, I know, I understand. Commercial.
But the thing is that, yes, but then the thing is that we have to take into account, I will not repeat, the entire sequence of events.
Yes.
What has happened.
Yes.
Right because it is not a fresh project.
Not fresh project.
It's not fresh.
Absolutely.
It's an old, it's a,
yes.
What do you call it?
But your lordship.
Eaten project.
Yes, but your lordship can't say, they no award this contract to them. Your lordship can't. This is not, no, that's not the power of the judge. And I will submit before this court that your lordship will direct them. Why do that?
The only thing which we're looking at is the decision-making process.
Yes, right, correct. And it's not that. How it is specific performance of contract. Specific performance of contract is one step ahead. Your lordship, if your lordship feel that yes, there is an inbuilt mechanism, there is a violation of principle of it goes. Now, in addition to that, you will also know, award the contract to them. Then it's specific performance. This is not the case. That's not the case at all. Now my lord will kindly see one trouble I am making, 178 of the writ petition. This makes it absolutely clear. 178 of writ petition 18 of 2024. Kindly see the last paragraph. I think it's before your 18 of 2024. I think it's before your lordship. 178, kindly look into it.
last part.
Last 170, that the instant order is being issued in accordance to the preliminary agreement dated, and this is the end of the matter, my lord. This is what you add, and is without previous right and entitlement government of Meghalaya, so and so. So these last 3 lines indicates that this is what you have taken in pursuant to the preliminary agreement. And this was still subsisting till the time when you terminate the contract. It was still subsisting. This is my
again,
lord.
in the same order.
I'm sorry, my lord.
In the same termination.
Yes, yes.
Where's that? That is at you see para 6.
Yeah, para 6.
That's caught my eye. Whereas in terms of clause 12 preliminary agreements, clearly stated that the preliminary agreement shall be valid up to a period of 1 month after the due submission of TPR or signing implementation agreement, which was earlier. In terms of clause 12 preliminary agreement has come to an end with 1 month submission of TPR, so and so. Therefore, preliminary is non-existent as of today.
Yes.
So then that means it's a contradiction in itself. If in para 6 they say that it's not in existence as of today, and on 22nd December 2023 they say that it's issued in accordance with the preliminary agreement. So are they looking only at the termination clause of the preliminary agreement, or are they implementing the conditions in that preliminary?
No, but
that is one thing which the court can't understand.
Yes, no, my lord. This clause number 6, where your lordship reading at page 177.
Yes.
This should have been indicated, my lord, if at all, 19th of February 2020. And they should not have communicated to me.
That's the wording of this also very confusing.
Now, what they want to say, my lord, what they want
to say? Apply your interpretation. What do you want to say?
What I want, what interpretation, what they want to say is that a DPR has been submitted by you on 30/12/2015.
You look at the mechanism of preliminary agreement also. We don't want to go there, but the thing is that, so they say clause 12, they said preliminary agreement should be valid for a period of 1 month after submission of DPR.
Yes.
Or signing implementation agreement.
Yes.
So the life of the preliminary agreement was supposed to extend only as per clause 12. So it's supposed to give DPR or implementation.
But then
so now they say that in clause 6 and in 6th letter. So in terms of clause 12, the pre-agreement has come within 1 submission DPR. That means 12/1/2016.
Now, my lord, now if your lordship looks into clause 6 and see clause 9, whereas you have placed
this letter, this termination letter also, you have to break your head to understand what it says.
It's a contradictory, my lord, I am telling you.
It's not clear.
It's not clear. And secondly, if your lordship see 9,
voicing it, otherwise.
No, your lordship will kindly see 9, whereas you have placed the proposal, you have placed the proper minutes of review, meeting dated 19/2/2020, seeking certain concession, namely 1, waiver of additional 10% so and so, include the development of approach road to waive of charges, lordship.
Yes, sorry.
9C, A, B, C, D, E. Lordship got it, A, B, C, D, E. Now see 10, whereas the said terms and conditions are acceptable to the court and also amount to post-tender modification and are also not in public interest. So if your decision is not based on 6, your decision thereafter, because you said that a flux of time, because of 30/12/2015, 1 month, thereafter
the thing is that you mean to say that once that 1 month is gone, then whatever, what relation you have between the ends, that means with regard to contract ends. It's
so
over.
if it ends, it ends.
John Sanadai.
If it ends Samadai, then there is no question of any communication to me. There is no communication.
That's the only
point.
Hang on.
And my lord, the point here is that number 2, that to what extent judicial review? Only to the extent of decision making process.
Part, Mr. Das.
One,
to what extent the judicial review in this case?
In this case,
because this is a very peculiar case.
Correct.
It's not a standing contract where you have been deprived or there's some dispute. It is a thing that was never born.
Right.
It was never born. It's fighting over a child is never born.
Yes.
Then how are we to decide?
Yes.
Yes.
Only, and my lord will kindly now.
Not bond, but liabilities.
Yes, I'll just, this is on termination. Now, the second point which my learned friend has pointed out, one is the communication is not amount to termination. It's only a title of the document, which is a caption, but recital one has to read because 2008 judgment. Your Lordship has looked into it. Please kindly look into 2008 4 SCC 451. My learned friend has relied on that. I think this helps us in this case. 2008 4 SCC 451.
In the affidavit.
No, my lord, the last time he supplied one judgment, 2008 4 SCC.
2008
4 SCC, case 451. This is BK Muniraju.
1 second. Just give the citation again,
Yes.
sorry. 2008.
Lordship got it?
No, wait. Just give citation again, 2008.
2008 4 SCC 451.
No, it's not here. No, it's not here. The one given by them is not here. Okay, we have only Orissa, 2013, 17, 2006, 2012, SC online, 2019, 2014.
There are series of judgments which has been
not Pimpri,
2008
8 SCC, no.
4 SCC 451.
We haven't found 8 SCC here.
Is a loose.
Oh, here.
Yes. That was my learned friend citing the judgment. Kindly see 18. This is what he cited. The document in question, which is filed as Annexure P3, has been titled or a style or title the certificate grant. In order to know the real nature of document, one has to look into the recital of document and not the title of the document. The intention to be gathered is from the recital in the deed, the conduct of the parties, evidence on record. It is settled law that the question of construction of document is to be decided by finding out the intention of the executant, firstly from the comprehensive reading of the terms of document itself, and then looking into, to the extent permissible, the prevailing circumstances which persuaded the author of the document to execute it. With a view to ascertain nature, the document has to be read as a whole. So now, we are not reading your caption, but we are reading the recitals. The recitals is now very clear. What is your intention? And termination, where you terminated our contract. So this is one minor. So it doesn't go by the reflex of time, which my learned friend has already submitted before this court. And now 3, hearing of the party, principle of natural they are not required to be followed in commercial contract, which I have already placed before this court, my lord. Now, and 4, my lord, read petition, we are seeking for specific performance of the preliminary agreement and cannot be granted. We straight away say that we have not asked for any specific performance of contract in enforcing this contract. We have not.
Yes.
Our case is that we have come before this court as a public law remedy challenging the arbitrary cancellation termination of PAs. And only we have sought for an alternative prayer for damages. Only alternative prayer, which we told before the court that we have given up that clause of that prayer also. And your lordship asked, and these judgments of Jagdish Mandal and the 1989 2 SCC has no relevance because 1989 2 SCC, which my learned friend has shown just now 116, it is regarding about a low-cost house, which subsequently the rate of the house was increased by 40%. So to what extent the court judicial able to can extend?
That, yes.
Yes. So these kindly look into the facts of this case, my lord, completely different. Again, Jagdish Mandal 2007-14 SCC 517 is totally a different or award of a contract.
No, principles have been laid down there.
Only principle, but all this principle has to be connected with the facts of the case.
These principles are applicable to the case.
Yes.
Yes.
So my humble prayer before this Your Lordship, is that your Lordship will kindly interfere with the order that has been passed by the authority. Both the orders in the writ petition on the ground that there is a violation of principle on actual justice.
Withdrawn earlier petition.
I'm sorry, my lord.
Because it's already dovetailed. It's already dovetailed into the second writ petition.
Yes, yes, correct.
Actually, the second writ petition doesn't need any other, discussion.
Only the minutes means they have minutes.
It doesn't need any what do you call
No, that's a decide to cancel.
finding any consideration.
There is no finding decided to cancel, but 24/2023, that minutes 22, that minutes has been, this is recorded, what is the minutes they have decided. To cancel, decided to cancel, minutes, 24/2022.
Minutes of meeting dated.
Meeting dated 24/2022 at page 130. 24/2022 at page 138.
Of the earlier petition.
And relevant.
File bullet points.
Yes. This is a bullet points, yes.
Well, even the replies we do.
I'm supplying one copy to the other side. 4 points.
And then you supply also any other bullet points supply.
We haven't supplied, my lord. We are ready also.
I will file, my lord. I'll file, my lord. Once argument is concluded, we'll file a short bullet point, my lord.
Is ready.
My lord, we'll go back and prepare the bullet point.
Go back, I don't know what again.
You can prepare fresh bullet points if they take time.
That's what I'll take time, then let it be. I don't know what is a bullet point they have coming up.
Bullet point, yes. No,
I know.
Progress. You see, whatever you have stated now, what is good that the court's mind, you have assisted the court very well in
yes.
The one report. What is especially what the arguments today. So you want to file fresh bullet points, no problem.
We'll file it, fresh bullet point.
We'll file it.
We'll file it a fresh bullet point. Are your lordship now keeping it for dispose already heard? There is nothing to be heard.
We only fix for filing bullet points after 1 week. Then
after 1 week, why not?
Yes.
Only one date. We'll take that date.
Parties are permitted to refund allowed to file bullet points within 1 week. List on.
Only date, please.
Yes, for bullet points.
20?
17th, my lord, 1 week.
17th filing bullet points. 17th.
17 or more.
Yes. 1 or 2 days can come on.
Yes. 17. Or it can be 18, my lord. Let it be on 18.
18th is a holiday here.
19th?
19th, yeah.
Yes, 19th. I'm deeply obliged, my lord. Giving lot of time.
Yes, I think wanted to conclude long time ago, but since it was taking a twist and turn.
So your lordship remembers when we at the time we argued the matter, we used to remember all the judgments.
Yes.
Our seniors would prepare with Shilekha Vidarthi.
Yes.
Mahabir Octo.
Mahabir Octo was,
how a turning point. Dayaram Shetty, all those judgments.
Bottom line.
These were the judgments from unique.
Cochin shipyard, all those cases.
Yes. Air Cochin, all those judgments. I'm deeply obliged. Thankful to my learned friend, Mr. Amit Kumar also.
Thank you. Great.
Thank you.
Please, Lordship. Lordship, in this view of the amendment of Meghalaya overtaking District Council Lower Primary School on amendment on 2018, because I am withdrawing this case because that earlier that there was this act was there where the primary school, even the pre-primary school, that section 3 was there, but there is a new amendment. So I pray, Lordship, that at least some liberty may be given because I think. Yes.
Whatever liberty in the council law, no one can deny.
Yes.
Yes, Mr. Petitioner subjects submitted due to the, PSA without to allow, PSA without to withdraw its instant petition, with ability to take other remedy if
Lordship.
available.
Yes, Lordship.
Not objected to by the single advocate, matter stands.
Much obliged.
Both on withdrawal.
Much obliged, Lordship.
Make it proper.